Hey everybody, Paul Ramblay here and another live stream. Quick intro, then we're going to jump right in. Okay, so yeah, my name is Paul Ramblay. I've been an estate planning attorney since 1991, 30 something plus years, helped over 10,000 people get and keep their estate legal affairs in order. The quick intro, my background, I own a national estate planning law firm that helps people all around the country get and keep their estate legal affairs in order, addressing issues like we're going to address in the live stream today. If you'd like to request a situation where we could have a Zoom meeting to discuss the particulars of what you're trying to accomplish from an estate planning perspective, feel free to click the link in the description and you can fill out a form and request a time to chat by Zoom. So let's jump right in. All right, so what we're going to talk about today is I get questions on this occasionally. It's the no contest clause. So I hear this from people who maybe they have a situation with children or spouses of children or grandchildren, and they come in. The relationships might be a bit stressed, and they're like, Paul, can somebody contest this, or how can I make sure that so and so can't contest it? Paul, somebody already told me, my daughter's husband already told me that the moment I die, he's got his lawyer lined up. He's ready to contest what I did. So I have to take a close look at the no contest clause provisions. That does vary by state. So I'll be talking about some generalities here. So what we're going to be talking about, four things today. We're going to talk about what a no contest clause is. And then number two, who should use a no contest clause. Number three, things to watch out for when you do use a no contest clause. And then we'll wrap it up with a case study, kind of an example of when it may and may not be appropriate. All right, so jumping right into number one, what's a no contest clause? Sometimes people mistakenly, they're like, Paul, I have three children and I have this son and he's kind of a problem. And he's made mention that he's going to contest stuff when I die. So can he contest it? Can he just say, when I die, can he say, I contest? And even though I left everything to my three children equally, can he just say, I contest and get everything? And then I have to kind of laugh and say, no, it just doesn't work that way. So we have rules we have to follow. And just because in America, people have the right to contest. People have the right to file a lawsuit. By no means does that mean they're going to be successful in their endeavor or in their contesting or in their lawsuit. So I want people just to remember that is while people may have a right to contest, doesn't mean they have a right to successfully contest. All right, so what a no contest clause is it's provisions typically in a will or typically in someone's living trust that discourages people from bringing a will contest or a trust contest because they could be penalized for arguing or filing a lawsuit trying to claim that a will provision or a trust provision or the entire will or trust is invalid. So a no contest clause typically looks something like if someone directly or indirectly seeks to nullify this will or any of its provisions, then it's presumed that they predeceased me without descendants. All right, so I've seen 100 different no contest clauses, so they're all likely to be different. They come in many different shapes and sizes, but sometimes those contest provisions define what a contest is. And so in my example, I said if someone directly or indirectly, well, maybe they didn't file a lawsuit, but maybe they threatened to file a lawsuit. And is that indirectly contesting will? Well, it might be. Seeks to nullify this will or any of its provisions. Sometimes someone says, well, the will in general is valid, is done right, but this particular provision where they said X, I feel like that is worth contesting. Well, if the no contest clause says that if any person seeks to nullify this will or any of its provisions, that no contest clause will apply. And then you say, here's the penalty. Then it is presumed that they predeceased me. So I leave $1 million to Joe, but I have a $10 million estate and Joe wants it all. So I pass away, Joe contests. Well, then what happens? Well, if the no contest clause is enforceable, Joe won't get his $1 million because it's presumed as if Joe died before me. Joe predeceased me. And that no contest clause said that it's presumed that Joe predeceased me without descendants. Because sometimes if someone is presumed or someone does actually predecease the person who wrote the will, their share potentially could go to their children or their descendants. So oftentimes it's a good idea for a no contest clause to say it's presumed that that contester predeceased me without descendants. So it just doesn't go to their kids. If Joe's penalized for contesting the will and he's penalized, but his share goes to his kids, that perhaps may not penalize Joe too much. So we want to cover that in the no contest clause. Okay. Are these things enforceable? I'll give you the lawyer answer. It depends. So in one state of Florida, they're not enforceable. Real clear statute, legislature in Florida created that statute where no contest clauses are not enforceable in Florida. So if you live in Florida and you put a no contest clause provision in your will or your trust, then you pass away, that no contest clause provision is not enforceable. Some people in Florida like to put the no contest clause in there anyway, because once somebody sees it, they just may be discouraged from contesting anyway, even though the legislation states that the no contest clause is enforceable. All right, now I'll kind of lump some states together. So in I think it's 27, give or take. In 27 states, the no contest clause is enforceable unless the contest is based on probable cause. So if probable cause for a contest exists, then the no contest provision is unenforceable. Some of you might say, well, what's probable cause? Well, probable cause is more than reasonable suspicion. So maybe a prudent and cautious person would believe that certain facts were true. So if mom was off her rocker and a televangelist went and picked mom up at her house, drove mom to the lawyer, the televangelist had the relationship with the lawyer wrote mom's new will to leave all of her money to the televangelist so he could go buy a new jet. Well, now and then mom dies 2 days later, and she just didn't have any capacity when the lawyer and the televangelist forced mom just to sign that will that she didn't have any idea what it said. I think if all that happened and there was a no contest clause in the woman's will, I think there's probably some probable cause there to believe that maybe there's some undue influence. And so that no contest clause that mom created in one of these 27 states may not be enforceable, which could be a good thing. Okay, so now in those 27 states, the clause is enforceable unless the contest is based on probable cause. 14 states, it's enforceable without regard to probable cause or good faith. A few states have this. It's enforceable unless the contest was based on good faith. So I also say that really it's in my view, it's the same standard of enforceability, whether that provision is in a will or whether it's in a living trust. No court and no legislature has said the will rule doesn't also apply to living trust, because living trust is kind of like a will replacement. They're very similar. Living trust is designed to enable assets to be passed to beneficiaries outside of probate. The will covers assets that are in your name. And when you pass away, the executor goes and the heirs go through a probate process to ultimately make sure assets are distributed to the appropriate heirs. So really the rules apply both to wills and to living trusts. All right, so who should use these no contest provisions as part of their estate plan? Well, kind of a no-brainer if you know someone who's going to be a nuisance. So I've had people come to me and say, Paul, I know it's going to happen. They've said it's going to happen. They've told other people it's going to happen. When I pass away, so and so is going to challenge my will, going to challenge my trust. They don't like it. They think they're due more. I want a no contest clause provision in there. So if someone's going to be a nuisance, if someone is disgruntled, then perhaps a no contest clause should be considered in order to just give that person a disincentive from contesting. Now, if you do want to provide that disincentive for them to contest, then there should be something at stake for the challenger to lose. So, for example, maybe a parent has two children and the two children are really difficult. They're not supportive. Relationship between the kids and the parent is bad, but the parent just doesn't want to exclude the children from their will or from their trust, because if they just completely exclude the children, then even with a no contest clause, the children have nothing to lose by contesting. So if the children don't contest, they get nothing because the parents' will or trust left nothing to the children. And if the children, now on the other hand, if let's say the parents' will left, I leave 25% to each of my two children, and I leave 50% to be divided among these charities. So and maybe the children, after the parent dies, take the position, no, I'm contesting this. I think mom's entire estate should go to the children, and I have some grounds to believe why I think mom's will may not be valid. Well, if that child who's entitled to 25% of the estate contests, and there's a no contest clause provision in mom's will or trust, now there's something at stake for that child to lose. Child's going after 50%, but by contesting, they may lose the 25% that they would otherwise be entitled to if they didn't contest anything. So if a child has nothing to lose, they're not a potential heir or family member, they're entitled to nothing under the four corners of the document, then there's no disincentive. They're going to contest even with a no contest clause, because they're going to go for it. They're going to say they have probable cause to contest, and they've got nothing to lose by contesting. So be aware that there may need to be something at stake for the challenger to lose. All right. Now, why do people contest? Because you can't just say, I contest and expect to be successful. There have to be reasons, legal reasons in place to contest. Why do people contest? What's their argument when they contest a will or trust provision after somebody dies? Well, one issue is this lack of capacity. So don't set your legal affairs up at a time and in a manner where a challenge based on your lack of capacity would not be successful. Don't wait until the last minute. Don't wait until you've been diagnosed with some dementia. So make sure you take care of these things at the appropriate time while your mind is still good, because someone could successfully challenge things if you wait too long when your capacity is not good. Your general capacity to understand things, it needs to be good when you put this stuff in place, because if you don't have the capacity to generally understand what you're doing, then that challenge based on lack of capacity could be successful. So don't let that happen. Another thing that you want to make sure is don't even make it appear when you create your estate plan that you're being influenced or adversely influenced by someone. So I've seen a situation where, mom has two children, a son and a daughter, and daughter sets up the appointment with the lawyer. Daughter picks up mom and brings her to the lawyer. Daughter is the one who has the relationship with the lawyer. Mom doesn't really understand what's going on. She just doesn't want to upset her daughter. And So daughter's driving the show. Daughter gets the estate planning documents in place so that daughter gets 75%, son gets 25%, or daughter gets 100%, son gets 0. And then mom dies, and son's like, whoa, time out here. My sister adversely influenced my mom. What my mom signed was not what my mom wanted, because my sister drove all of this and just influenced my mom too much into doing something that mom would not have done had all of that influence that my sister put on my mom would not have taken place. So don't ever let it even appear that you're being adversely influenced by someone. And then a third thing that people can test, and this is part on the lawyer, is sometimes people can test the validity requirements. You know, when mom signed her will, she didn't follow all of the state's requirements that make it a valid will. You know, there's many requirements that are in place to make a will valid or make a trust valid. Maybe there's a question about whether the appropriate notary or the appropriate witnesses participated, and whether they were in the room, whether they were related. There's questions about whether the language in the will was the right kind of language to make it a will or make it a trust, or maybe language in the document was ambiguous. So some of that's on the lawyer, some of that's on the person writing the will or trust to get all of that right. So ideally, you want to eliminate all of those opportunities where people can say, well, wait a second here. This is a little shaky. This is a little questionable. I'm going to contest. You want to eliminate those opportunities. All right. Also, I'd say maybe another important thing to watch out for or to do is either document or communicate your reasons for either disinheriting someone or providing that no contest clause. So maybe you have 4 kids and you're leaving everything to 3 of your 4 kids and you're excluding one. Or maybe you're just leaving that one $25,000 or $100,000, and then your other children share in your $3 million estate. So on its face, that may not look right to some people. However, if either in the will or trust, or either in a separate communication or a separate writing that you do that's outside of the legal documents, you clearly communicate your reason for why you're leaving that child nothing, or $25,000 or $100,000. Maybe you write out, you know what, these 3 children who I'm leaving my estate have been really supportive. They've helped me. I was sick and they all helped me. My other son wouldn't even call me on my birthday. And so for that reason, and this has gone on for 10 or 20 years. And so for that reason, I do want to acknowledge my son who never acknowledged me. I do want to acknowledge my son for leaving him $25,000, $100,000. However, I think it's right that my other 3 children share in what I've accumulated over my lifetime. So documenting or communicating your reasons for either the disinheriting or the no contest clause might be enough for people to say, you know what, okay, I don't want to get involved in that. She stated her reasons pretty well, seems to be valid. I don't think I can overcome that. I'm not going to contest anything. All right, so what I want to do now is just do a quick summary. If you have any questions, comments, experiences that you want to share, the no contest clause rule is kind of all over the place. Yeah, in estate planning, we have our federal estate tax rules. We have capital gains tax rules, income tax rules. Those apply across the board, everybody in all 50 states. No contest clause, you don't really see a whole lot written about it or said about it, because it is so state specifics. You've got one state completely unenforceable. You got about half the states say, well, it's enforceable unless the person bringing the contest has probable cause. You've got a few more states saying it's enforceable unless the person who's bringing the contest does so in good faith. And you've got some states, give me a second here, I'm turning this off. Got a light blinking. You got some states that say, yeah, under all circumstances, a no contest clause is enforceable. So So as we sum up here, and if you have any questions, comments, feel free to go to the chat. I'm going to go into that before we wrap up here in a minute. Bottom line here on this no contest clause stuff, the no contest clause is designed to discourage people from contesting a will or trust. You might think, well, that's something everyone should have in their estate planning documents. I can see a circumstance where maybe you wouldn't want it in there. Maybe husband dies, wife gets married for the second time, and she's older and she's in love, and her husband has influence over her, and he does get her, and she does it on her own volition, but he does get her to write a new will, leaving everything to her second husband. And maybe she leaves a token inheritance or bequest to her children, leaves everything else to her second husband. Now, if she puts a no contest clause in there, that could be trouble for the kids. And she was influenced. That could be trouble for the kids, because if the kids contest it, they get nothing. Maybe if the no contest clause was not in there, the children could prove that the second husband adversely influenced her into signing a will that she really didn't intend to sign. And the fact that there wasn't a no contest clause may have helped in that set of circumstances. So generally designed to discourage people from contesting a will or trust, but it has to be used in the appropriate circumstances. Its enforceability does depend on the state. Florida, unenforceable. Large block of states, enforceable unless based on probable cause or good faith. And if you're going to use a no contest clause, be aware that something should be at stake. So perhaps a minor bequest should be in there for that contester, so that they know that they would lose that if they did contest. Not sure about including an inheritance to someone just because you don't want them to contest, but just be aware that that's a strategy out there. All right, so what I want to do now is I want to jump over to the questions. If you're going to ask a question in the chat, feel free to just be as clear as you can. Some of them I really don't know what people are asking. Like the first one from Salifu, I really don't know what they're saying. So good evening. There we go. What if King Otis Club? What if one is a beneficiary of a living trust, but not the will, and they come in as heir of the estate and contest the will? So they are a beneficiary of a living trust, and they contest the will. So typically when someone has a living trust, they have a will, and the will says, if there's anything in my name when I die, I leave it to my living trust. And so I guess in here, is there a no contest clause somewhere? Let's say there's a no contest clause in the will, but they're a beneficiary of a trust. That one's I think a judge is going to decide that one. Is a judge going to say, because there's a no contest clause in the will, maybe it was just overlooked by not putting it in the trust, and so the person who contests gets nothing from the trust? I don't know that that's accurate. Depends on facts and circumstances. But if someone's a beneficiary of a trust and there's no contest clause in the trust, but there's a no contest clause in the will that says if anyone contests this will, then maybe they're entitled to their portion of the trust. So that's a crazy set of circumstances, and would need to know more about that one. All right. Thanks. Larry, you called me Joe. I thought we were better friends than that. So, but that's okay. Happens to the best of us. Okay. Rally Sport found 5 different wills with no dates and 4 other siblings trying to leave out the 5th child. It did not too good for the 4. 5th got a share. Okay. Found 5 different wills with no dates. Okay, so that's the first thing you said. So, estate planning documents, one of the requirements is that they be dated. So that's a problem there. 4 trying to leave out. So it looks like there was 4 siblings were trying to make sure a 5th sibling didn't get anything, but they got something. So there's a story behind all of that, I'm sure. So thanks for the comment there, Rally Sport. Christopher, the trustees changed the trust, and my wife was left with nothing. So that one again, more questions I have. So when people have a trust, there's a settlor who sets up the trust and determines all of the provisions of the trust. And there are trustees who are in charge of managing the trust assets. And in the typical living trust scenario, they're also in charge of dispersing the trust assets to the trust beneficiaries after the trust settlor dies. And you've got beneficiaries. So you say the trustees changed the trust. So a trust typically can't be changed or amended or restated by a trustee. Typically, it's the trust settlor that only has the right to change the trust. So something's weird there. My wife was left with nothing. How about if one has suspicion and some proof that the irrevocable trust was changed after the grantor passed away? The trust copy I received was not notarized. There are some states where there isn't a notary requirement for a trust to be created. So you'd have to check your state requirements there. And again, here's another one where you're saying the irrevocable trust was changed after the grantor passed away. Well, for that to work, the grantor would have had to have stated in the trust that somebody had the right to change it after the grantor died, which is almost never the case. So if it was changed, how was it changed? I'm starting to gather with some of these questions that I'm getting. Did the trustee ignore the trust provisions after the grantor or settlor died and distributed assets in a way that violated the terms of the trust instrument? Maybe so. King Otis Club, the real property went through probate, and the trust said that trustee can do whatever they want with all of the personal property. Never seen that before, where a trust says, okay, after I die, the successor trustee can do whatever they want to with it. Now, I've seen it where, let's say the successor trustee's name is Fred. I've seen it where a trust says, when the grantor dies, Fred is the trustee, and all of the personal property shall be transferred out of the trust to Fred because that's what the settlor or grantor wanted. But I don't know that I've ever seen, and if I did see it, it wasn't right, where the successor trustee gets to dictate who inherits from that trust. I have seen it where the successor trustee does inherit from the trust, and then they voluntarily distribute assets that they're entitled to inherit from the trust, but not typical for a trustee to have that kind of discretion where it says they can do whatever they want. All right, Cricket from Cali. I live in California. My husband signed a quitclaim deed when I bought my mom's house. Do I have to have him sign the revoke? I'm only putting the home in the trust. My husband. When you bought your mom's home, your husband signed a quitclaim deed. Do I have to have him sign the revocable trust if I am only putting my home on the trust? So if it's a home that is yours and yours only, it's not community property with your husband has no ownership interest in it, yes, you can create a trust, you can put your home into it, and that trust works because it consists of only your property. I don't know if that's what you're getting at. Really, all of these questions, I'm having to read stuff into it. So don't rely solely on my answers. You'll need to talk to an attorney and get some good advice, and because we're talking about some valuable stuff here. Jacques says, if I have received a descendant's irrevocable trust, can the trust buy a house and I live in it for free as a beneficiary? If I have received a descendant's can the trust buy a house? So let's break that down. If I have received a descendant's irrevocable trust, does that mean somebody died? They left assets to an irrevocable trust for you because you were a descendant? And if so, can the trust buy a house and I live in it for free as a beneficiary? It all depends on the trust provisions. The trust provisions say what everyone's rights and responsibilities are. So tough one there. First thing to do, let's look at the trust instrument. Johnny 5, does a no contest clause need to apply to every beneficiary? Good question. Yeah, again, state law issue, but I think that a no contest clause can apply to certain people who can or can't contest it. So that's a good question. So you may have this one person who you just, man, they're just disgruntled and you don't want to give them the rights to contest things, but you feel like the other heirs are reasonable and you'd like them to give them an opportunity to correct things if things were done incorrectly. So good question. I would say generally yes, a no contest clause could apply to only certain individuals. Best question of the day so far, Johnny Five. Good job. All right, let's see here. Just hit the like button. I am going to ask you, yes, to hit the like button and subscribe. Thanks, Ann, for pointing that out. Ray, can you leave a blood child out of the will and leave everything to an adoptive child in Louisiana? Okay, so it sounds like you have a natural born blood child, as you call it, and there's also an adopted child. Louisiana has its unique forced heirship laws that say that if when you die, you have a child who's 23 or younger, or they're incapacitated, and there's a definition for that, then you have to leave them a portion of your estate. And there's a calculation for that based on how many forced heirs and how many children you have. So if they're not a forced heir, yes, you can leave them out and leave everything to whoever you want to, including the adoptive child. But the adoptive child could also be a forced heir if they meet one of these forced heirship requirements. So Susie, Lisa Marie's estate was changed somehow after she died. Amazing her mom collected from her grandkids. Yep. Thanks for the comment. I don't have anything to add to that, but thanks, Susie Aspen. King of the trustee was the sole beneficiary. Okay, so that's starting to make some of King Otis Club's previous comments make sense. The trustee after the settlor or grantor died was the sole beneficiary. So yeah, he calls all the shots. He's managing the trust and he's entitled as the sole beneficiary of the trust. He gets everything. Now, maybe that's what the settlor or grantor wanted. That could be a whole nother story, but that makes more sense. If a letter of explanation for the reasons was left by the trust settlor, does it become discovered in court? That's an evidence question. It's a good question. I'd have to ask one of my litigator colleagues about that. So I don't know. I'm not a litigator, but good question. Jacques says, does every named heir have to sign off on the provisions of the will? Okay, another one, Sarah. When a person writes a will, then certainly none of the heirs are signing off on anything while the person who wrote the will is still alive. Once that person who wrote the will dies and there's a probate proceeding and all of the heirs are part of that court and attorney involved probate proceeding, probate proceedings also can vary state by state, but generally, yes, all of the heirs have to participate and kind of, quote, sign off on this petition asking a judge to allow for the transfer of assets from the estate to the heirs. So that can vary from state to state, but typically, yes, all of the heirs are participants in the probate proceeding when somebody dies. Hubby and I both on second marriage 23 years. We have a no contest clause for his one child and my two kids, even distribution to all three. So there you go. So probably smart move there because he has one child and he might say, well, I want to contest the validity of my father's stuff because if my father's stuff is invalid, I'm entitled to all of his part. I don't want just 1/3 of what my father and stepmother have. I want all of my father's share. So a no contest clause could prevent something like that. So good job, whiskey business. Just don't be drinking whiskey right before you sign your stuff. That could cause a challenge. Okay, that's my only joke of the day. Already received the inheritance I got in my in my will. You have no contest provision in your will. Good. Okay, so we're going to wrap this up here. A lot of really good questions about the no contest clause. I got a slew of live streams scheduled for the rest of the week. This was the one I wanted to kind of get through because it's a little unusual. It's very state specific. You don't see it a lot. But dive into 4 more this week. Check my YouTube channel's live tab, and you'll see them all listed out same time every day for the next 4 days. Make sure you do subscribe, hit the button that helps. Make sure you hit the like button, and we'll see you next time. Thanks, Larry.